25-00332. That is, correct my pronunciation, Arabai Mburwa. Will the parties please, People versus Arabai Mburwa. Will the parties please introduce themselves for the record? Mrs. Zell.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Carter.
May it please the court, David B. Carter Jr. on behalf of Ms. Mburwa, who is present standing at council table.
And ma'am, you are Arabai Mburwa, is that correct? Am I saying that correct?
Mbera.
Mbera. Okay, thank you. Mbera. This is the time set for a sentencing in the matter. Mrs. Zell, is there any restitution on this matter?
There is no restitution on this file, Your Honor.
Mr. Carter, have you had the opportunity to go through the pre-sentence with your client?
I have.
Any additions, deletions, or corrections?
I guess additions would be that my client recently had a baby, and so she has a very young child at home.
All right. Anything else, Mr. Carter?
For corrections, additions, or deletions, no.
All right. Allocution of Mr. Carter.
Thank you, Your Honor. Your Honor, if you're to remind the court a little bit, and as the pre-sentence indicates, that there was this incident involved several individuals, and ironically at a baby shower.
Right.
And not to belittle anything my client has done, she's taken responsibility for her act, but she wasn't really the main aggressor in this. She actually was thinking, she came in late thinking that there was an issue between an individual perhaps attacking one of her friends. She ended up using a broom to hit somebody with, and obviously that is totally wrong, and she understands that. She's 29 years old. She's never been in trouble before. I think this was more of a not reading the room correctly, and she acted impulsively on that. I think she's learned a very, very valuable lesson going through this whole thing. I went over the conditions that the PSI is requesting her to follow. I don't see any issues with that, except perhaps the obtain and maintain employment. This is not anything that had anything to do with economics or any economic crime. She is a mother of a very young child. There's nothing in this report that indicates that the family unit needs my client to work, and to put that in a condition of probation, I think is kind of overreaching. But with that said, my client does want to maintain or seek some part-time work just to get her out of the house, but to make it a condition of probation, I don't think it's appropriate. So I'd ask the court to follow the recommendation. It's asking for 12 months probation. I don't believe that 12 months probation is needed in this situation, considering my client's activities in this crime. So I'd ask the court to consider a lesser amount. Thank you.
Thank you. Ms. Zell, any comment on the sentencing of Ms. Arabai and Ms. Mburwa?
Just briefly, Your Honor. First, we would like to extend our congratulations to the defendant for her new baby. Second, Your Honor, we would just like to ask that the 12 months of probation be followed with the Zoom recording. We don't think this will be such a hardship with the new child in the home. Additionally, Your Honor, the 12 months is what the other co-defendants received in this case, and we would ask that that be consistent among the co-defendants. Thank you.
Thank you. Ms. Mburwa, is there anything you'd like to say to the court before the court passes sentence? All right. I'm in agreement with Mr. Carter and what he's indicated concerning that. I don't know what the relationship was between the co-defendants and yourself, and the victim in this matter, but there was no criminal histories. There was no evidence of so I'm gonna put all this up because you're the last sentencing on this matter to a learning experience. All right. Well, we're going to learn from this in regards to an appropriate action or reaction. I don't know if there's been a long-term thing going on between the victim and the other, which led to this, the assault at the baby shower. But I think everybody's learned that this wasn't the appropriate reaction. With that being said, this is for the guilty plea on March 27th, 2025 to assault and battery. The court's going to order following the sentence and spend 93 days in jail, credits given for 1 day previously served, suspend the 92 days upon successful completion of probation. So no upfront jail. All right. Fines and costs will be $200 fine, $200 cost, crime victims' rights fee of $75, state minimum cost fee of $50. I will put you on probation for 12 months, but I'm not gonna make obtaining and maintaining employment a part of that. Okay, we're gonna strike that. So you're really under the same probation order that everybody else is in this matter. And I think there were 5 or 6 co-defendants in this case, in this matter. Regardless, so I'll give you a total number. That's $400 fines and costs, $75 crime victims' rights, $50 state, and then $360 for probation for a grand total of $885. Probation is for 12 months. It can be via Zoom. All right. So after this, you might want to find, I don't know, Mr. Sumter's back. He also recently had a baby. So I don't know if he's back, but you should jump on board to find out. He's the only one who can violate your probation. Okay. No contact with the victim, Fataman Ali or Changwa Ali, or to be within 2,000 feet of where the victim lives and works, goes to school without consent of this court. No assaultive or threatening behavior. No use of possession of alcohol, marijuana, or controlled substance without a prescription. That's really not an issue. No bars or nightclubs. That's probably a good idea. Complete the following rehabilitative services, pay fees, and provide proof of completion to the court. Moral recognition therapy, the MRT class. And then I will not order the obtain or maintain employment just because Mr. Carter makes a good point, and you're not in the same circumstances everybody else is concerning this. Not purchase or possess firearms, ammunition, or weapons of any kind. Do you have any questions questions of me concerning the judgment of sentence, Ms. Imberwa? Mr. Carter.
Will this probation be entitled to 1/2 reduction if she?
I think it's 6 months if the probation comes to me and says that she's all caught up and everything. Yes, I do think it falls under that. It is, but it may not. You'd have to check with the probation officer. It's an assault of crime, but I don't know if it fits under that assault of crime probation.
All right.
Yeah.
I don't think I think those are more with domestic violence.
I think those are DV cases. Yeah. I do not think they're assault and battery, but I really don't know.
Okay.
So if Mr. Sumter comes to me and says everything's paid up in 6 months probation, that would fall under this guideline. All right, ma'am? All right. I will sign the judgment of sentence. I don't know if we have to make it look pretty just because. Yeah, I'm just going to strike that, and then they'll hopefully know what I mean by that. Anything else for the record in docket 25-00332, Mrs. L?
Not for the people.
Mr. Carter?
No, Your Honor.
All right, Ms. Imberwa, good luck to you, okay?
Thank you.
Mr. Carter, have a nice 4th.
Thank you.
You're welcome. Okay. Where did you want to head next, Mrs. L?
I believe we are ready on the Morris Adams case.
Okay. Mr. Goodrich and Mr. Feigelson is covering for Mr. Goodrich. All right, so we're on the record in docket 25-01755. That is people of the state of Michigan versus Morris Adams. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Mr. Fikes.
Yes, Your Honor, good morning, Assistant Public Defender Stephen Feigelson on behalf of Morris Adams, standing to my right, also standing in for Mr. Goodrich today, Your Honor.
All right, thank you. And sir, you are Morris Andre Adams, is that correct? Thank you. This is the time set for a preliminary examination today. Mrs. L, how we proceed?
Your Honor, at this time, the people's necessary witnesses for this case have failed to appear. We did send them a subpoena, and we do believe that subpoena was successfully served. And we have had contact with the complaining witness in this case. However, she indicated that she did not agree with our charges. So we do not believe that she will be here today. At this time, we do expect a motion from the defense.
All right, Mr. Fikes.
Yes, Your Honor, Mr. Adams stands ready to proceed today. Yet they don't have the necessary witnesses, Your Honor. We'd ask for dismissal. We are aware it is without prejudice, Your Honor, but nonetheless, we ask for dismissal.
All right, I'll have printed out the nolle prosecutor dismissal without prejudice based on the defendant's motion. Thank you. All right, so I'm in possession in docket 25-01755 of the dismissal without prejudice, which means, Mr. Adams, based on the representations of counsel, people are unable to proceed. The subpoenas went out. This case will be dismissed based on your motion without prejudice, which means the people could reissue if they choose to, but for our purposes today, the case is dismissed. All right, sir? All right. You have are you still on GPS tether? So that'll be taken off at the jail and in Mason. So you should go back there and we'll email the company to expect you. And then I would wait about 4 hours for the system to purge everything. You might want to keep the copy of the dismissal with you because it'll take about 4 hours to purge from the computer system, all right? All right. Anything else for the record? In docket 25-01755, Mrs. L.
Not for people.
Mr. Fikes.
Nothing else on behalf of Mr. Adams, Your Honor.
All right, Mr. Adams, you're all set. You should get a copy for your record of the dismissal. All right, sir? All right, thank you. Mrs. L, where did you want to head next?
To the hallway to find defense attorney.
Okay, so let me know when you're ready. And Mr. Mask is not in custody, is that correct?
No, he is in Eaton County.
He bonded out.
Oh, you bonded out, okay.
Then
He bonded out and then made his way to Eaton County.
Or did he bond, wait,
He bonded out and he's on tether according to what LPD advised.
Okay.
So he may show up, he may not today,
okay,
Mr. Mask. But we. So we'll wait on that. Just let us know when you're ready.
okay, thank you.
Thanks. Let's take a break.
All rise. Be seated, thank you.
Can I get a copy of that as well?
Nope. Roll out.
Okay.
Did I ask me before I stapled it already?
No, doing it, my fault. It's on me, I'll take it. You just give me a hard time.
Yes.
You don't see me anymore.
I know, it's a good thing.
Yes, I know. I like it over here, but I think it's all right.
Oh, that's where you are now?
Yeah.
I thought you were at Circuit.
I am, but I started with the counties. But I think they're gonna be sending. Have a good holiday.
You too.
Oh, geez. Oh, Bill, that's good. Oh, yeah.
So they're going up to see. I had to work tonight, so they're coming back Saturday, so it's not for the
Oh, yeah.
3-hour drive, it's for 2 days, especially for traffic. So just hanging out here.
Sure.
Yeah, one.
Yeah, those are the
My other grandparents.
Okay. Yeah. That whole area. Cool. Enjoy the tour.
Thank you. You too.
Yes.
That is people of the state of Michigan versus Montel Lyons. Will the parties please introduce themselves to the record? Mrs. Zell.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Sarnes.
Good morning, Your Honor. Jacob Sarts, the fourth Assistant Public Defender here on behalf of Mr. Lyons. Mr. Lyons is present at council table. He's standing by.
And sir, you are Montel Lyons, is that correct?
Correct, Your Honor.
Thank you. This is the time set for a preliminary examination today. Mrs. Zell, how we proceed?
Your Honor, it's my understanding that at this time, there's going to be a waiver of the preliminary exam. A previous misdemeanor offer was extended. However, that offer was made, it was only available here in district court. Upon waiver to circuit court, the misdemeanor offer is no longer available. We are willing to extend another offer at this point to be left open until the first pretrial in circuit court. And that would be to plead as charged, and we would drop the habitual offender notice.
And is that a fair statement, Mr. Sarnes?
Yes, Your Honor. Thank you.
That's open until the first pretrial in circuit court.
Correct, Your Honor.
With that understanding, Mr. Lyons, Mr. Sarnes may inquire of Mr. Lyons of his waiver of the preliminary examination.
Yes, Your Honor. Thank you.
Mr. Lyons, you understand you have a right to a preliminary examination within 14 days of your date of arraignment, a preliminary examination, 21 days of your date of arraignment. Preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime's been committed and the identity of the person who committed that crime. You are represented today by Attorney Jacob Sartre, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it is your wish today to waive your right to a preliminary examination, have this case continue to circuit court. There's an offer that's been extended on the record. It'll be open till the first circuit for a pretrial. Regardless, negotiations are continuing on the case. Is it your wish today to waive your right to a preliminary examination today?
Yes, it is, Your Honor.
Ms. Zell, do people also waive their right to preliminary examination?
We do, Your Honor.
All right, I'm going to be in possession of the documentation paperwork. Thank you, Mr. Sarts.
Thank you, Your Honor. May I approach, Your Honor?
May.
Thank you.
Mr. Sarts. All right, I'm in possession of the bind over documentation on 25-01076. It is signed by all the parties. I will indicate that it's going to be waived on today's date, July 3rd, 2025. Anything else to come to the court's attention before I sign the bind over documentation, Mrs. Zell?
Not the people.
Mr. Sarts.
Just ask the bond be continued, Your Honor. Thank
All
you.
right, thank you. Bond is continued in this matter. Mr. Lyons, I'm going to sign the bind over documentation. You'll get your next date to appear in circuit court. Your time in district court is done. You'll get your next date in circuit court from your attorney, Mr. Sarts. All right.
Thank you, Your Honor.
All right. You're all set, Mr. Lyons. Thank you.
Thank you.
Thank you, Your Honor.
Thank you, Mr. Sarts.
Your Honor, I'm going to step out just briefly to speak to a witness.
All right. We'll take another break.
Whatever you think.
So Etheridge coming on Delmore.
He was here, but I told him that his client's running 30 minutes late, so he
Okay.
said I gotta go back to Buchanan then.
All right.
Which will never see.
Two probation bodies. Yeah, just let me know when.
I know Jared Austin's still held up.
I'll take a look.
All rise.
Two probation violations, don't know what that.
Be seated, thank you.
Mr. Slama here.
Hello.
Just waiting for the defense attorney. Once he's out of the report, we can let you through. I'm sorry about the wait.
Okay.
So, just explaining what I think. Obviously, it's going to be literally a misdemeanor. He decided he's gonna take his chances with felony, which is insane to me. Kind of seems, it's a choice, but he has a right to trial. So I placed another offer on the record for the sake of the defense attorney. But I don't actually have permission for it, but I know it should be fine because we've already offered a misdemeanor. I'm just taking more than half. So I'm not even. With that, he'd have to do in circuit court, the circuit court attorney who gets it probably said, like, you know, and then they need to do that, but I at least hold it open for them to do that first opportunity. I don't know the word. It is what it is. Early Winston, I ran most of his exam in different, we just need to get his ID on it. And then Tyrion Johnson and Hardy, there's 3 Arnos, 1 causing injury. I have 2 officers here for that. They'll be. So. So Tyrion Johnson will run for sure. Early Winston will finish up for sure. And he keeps it. other donating fund. So I'll put it on record that he came for the PCC. All that is- I didn't show last one. I was like, I'm sorry, I had to like go through the checklist in my head, otherwise I get the cases jumbled. today for that case. If we do, there are certain rules. That we can enforce, such as what- G is capable. She's talking, she's still connected to the board. Things that we keep it from being like, oh, no. Hey Megan, what was the probation violation that got added to our schedule today?
I have Michaela Porter and Thomas or Curtis Thomas.
What's the one that James Harris was emailing about?
Is it the Emilio Lira?
Oh, is that it?
Yeah. He's in custody though.
I think that's why you're here, so
That's why
I think that's why you're here, right? Is for, what case are you?
I'm here to cover Porter, Thomas, and
Lira.
Lyra. Yeah,
Her?
You know Lira's in custody?
yes. And
making sure.
he's the one I don't need to talk to.
Okay, perfect.
Yeah.
I just like to let people know, 'cause especially if you're covering, you don't always know that. So,
Of course, yeah,
I mean, even when some of these defense attorneys aren't covering, they don't know that.
yeah.
It's like you're in the
I never
headlights
know
and I'm
it.
like, oh, they're in custody. Oh, they are?
Well, yeah, sometimes you check VineLink and it's just not up to date
Yeah.
and the roster's not up to date.
It always just makes me laugh.
Yeah. But I do need to talk to Porter and Thomas once they're.
Okay. Yeah, it's not set till 10, so they got
Hey,
time.
You made it.
Yes.
Did you get your PCCs done? Woohoo. I was told I'm not allowed to steal you from that courtroom today, so that was fun. Apparently they're trying to get out of there because Shelley's not supposed to be here today. She was supposed to have the day off.
Oh,
I
that's-
I
that's-
told
There's a
her.
whole bunch of drama with the
Yeah,
court
so,
reporters.
so I was told to let you finish.
get in the middle of that.
Yeah, let me do. That's why I was like, you know what? Just let Ward do her docket. Oh, sorry.
All right, Mrs. L, where are we heading?
If we could head to Roy Lewis, actually.
I'm grabbing the files.
Oh, just once the files are.
All right.
I forgot to grab them, my apologies.
No, you're fine.
Is that Mr. Fikeson's plan?
It's Mr. Milk's client, but Mr. Austin will be stepping in.
All right. Oh. All right, so we're on the record in 24-03240 and 25-00159. That is people of the state of Michigan versus Roy Lewis. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the people.
Mr. Austin.
Thank you, Your Honor. Good morning. Jared Austin appearing today on behalf of Mr. Lewis, standing in for counsel of record, Mr. Milks. Mr. Lewis stands present to my right.
And sir, you are Roy Lewis, is that correct?
Yes, I am.
Thank you. This is the time set for this was a fail to appear, and then there was a bench warrant issued, 48-hour hold, and it's been brought to my attention. This is how are we proceeding?
Your Honor, it's my understanding that today we will be stipulating to the finding of competency that we received. And I apologize, I'm pulling up the document now to see what that date is.
I think that was received on June 17th.
That looks correct, Your Honor. That is the date that I have on this as well. It appears to be completed by,
Andrew Sheff.
correct, Your Honor.
Is that what you have, Mr. Austin?
I assume so, Your Honor. I have not personally
All right.
viewed it. I have been in communication with Mr. Milks regarding the matter. He has reviewed and stated that he would be stipulating to its findings.
All right, and that's Ms. L, that's the indication is that the report dated June 17, 2025 from Mr. Sheff will be the stipulated report concerning both 24-03240 and 25-00159. Is that correct, Mrs. L?
That is correct, Your Honor.
That's your understanding from Mr. Milks, Mr. Austin?
It is, Your Honor.
All right. Well, then I will find that I will stipulate to the report that was filed, which means that I will find the defendant competent to stand trial on 24-03240. And this case shall continue to the next stage of the criminal prosecution. I'll sign that. That would be today's date. And then I will also sign it in regards to 25-00159. And then, so we should get a new date do we need it set for PCC or prelim, Mrs. L?
I think it might be best to set it for a PCC first.
PCC, and then the following prelim, I would,
concur with that, Your
yeah,
Honor.
I would think that
I
that
think
would
that's the
be.
best practice. I certainly don't see any harm in doing it that way.
Right, so we'll hold it for the PCC. That's the belt and suspenders approach, I think. And we'll set it for PCC on July 11th at 9 o'clock. And then did you want to hold off on the prelim? Setting the prelim, or we can set it, we can set the prelim with the PCC. It's entirely up to you.
I think we can go ahead and set the.
All right, we'll set the prelim for.
Thursday, July 18th at 9:30.
Right, we'll set the prelim for the following week, July 18th at 9:30. You'll receive notice for both of these, Mr. Austin. You can give it to Mr. Milks, but we'll provide the client with a notice for both of them. Anything else for the record in 24-03240 or 25-00159? I assume this takes the part of the bench warrant that I don't know if the bench warrant was ever issued.
We're getting ready
Okay,
to
so-
issue this morning.
Okay, so we'll quash. There's no need to quash, we'll just not issue it. Because we put it on with a 48-hour hold. my understanding that there might have been some miscommunication concerning the June 27th date. So at this time, Mrs. Are you requesting any type of anything concerning Mr. Lewis?
No, Your Honor, people are satisfied.
Mr. Austin?
Yes, Your Honor, thank you. As long as the bench warrant is not issued, that's all we would be asking for. Mr. Lewis has presented himself, here today. So I don't think there's going to be any issue with that moving forward.
I'm gonna put on the ROA that the bench warrant was not issued, but that's just for my purposes because the bench warrant was held on with a 48-hour notice and then it was never issued at all. All right, so Mr. Lewis, you should be back here for the conference on July 11th at 9 and the prelim on July 18th at 9:30, and you'll receive notice for both of those from my court officer. All right, sir?
I'm having a difficult with mail.
What's that? She's gonna just give it to you, give you the notice.
Before you leave here today.
Yeah, so you'll leave here with the notice on when to come back. All right, anything else for the record in 24-03240 or 25-00159? This is L.
Not good people.
Mr. Austin.
Nothing additional by Mr. Lewis, Your Honor.
All right, you're all set, Mr. Lewis. Stand by and my court officer will get you the notification, okay? Thank you. It's printed, it'll be all yours. All right, Mrs. L, where did you want to go to next?
If I could have just one moment.
Absolutely. Or tell me if we need to bring up anybody.
I believe we could bring up Emilio Lira for the probation violation hearing.
All right, so after Miss Slaviak provides notice, then she'll go get Mr. Lear.
You want to do this? You know how to schedule? There's a count hearing, there's all sorts of codes that have to go in there.
Then we'll get Mr. Lira. This is here on Mr. Mask
And Mr. Christie.
and Mr. Christie. Yes. Mr. Tullamore.
Let's go ahead and hold those cases there. All right, Your Honor, I think we're ready on Matthew Christie.
All right, did we need to bring up Mr. Christie?
Was he in custody?
Yeah, he's in custody.
Then yes, never mind, you can't call that one.
Let's do Mr. Lira first and then we'll when we go take Mr. Lira back, we'll bring up Mr. Christie.
I do believe we could put the Keys mask on the record at this point.
All right.
Is
And
that-
Mr. Mask is the one who was let out of custody.
Correct, Your Honor. He is present today.
Okay, he's present. All right, so we're on the record in docket 25-01620. That is people of the state of Michigan versus DeQueese Mask. Will the parties please introduce themselves to the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of DeQueese Mask.
And sir, you are DeQueese Mask, is that correct? Thank you. This is a time set for a preliminary examination today. Ms. Ezel, how are we proceeding?
Your Honor, at this time, the people would be ready and able to proceed to preliminary exam today. However, it has come to my attention that Mr. Mask may be seeking private counsel and retaining that private counsel. I'm going to defer to Mr. Lee to make that record.
All right, Mr. Lee.
Yes, Your Honor. Mr. Mask has informed me that he is intending to retain Mr. Dwayne Boyd. Mr. Boyd has previously done some work for his family, and he feels comfortable utilizing his services. We would ask for a good cause adjournment for 2 weeks to allow time for Mr. Boyd to substitute in and receive discovery.
Hey, there's been one PCC, and then June 20th at 2:00, and we granted a good cause adjournment because Mask was in Eaton County, and he's now present. I don't have a problem with the good cause adjournment concerning Mr. Boyd, as long as everything's done on that 2-week time frame. If not, that's so D is requesting adjournment to retain counsel. And the counsel is, at this point in time, the plan is to retain Dwayne Boyd.
Yes, sir.
I find that this is a good cause adjournment at this time. If Mr. Boyd shows up and wants another adjournment, we might have to waive the 21-day rule. You're not doing it now because this is an acceptable reason for good cause, but we'll reset the PCC date with the new retained counsel, and that'll be set for July 17th at 8:30. And then we'll wait on the preliminary examination date, because we have to coincide it with the council schedule. Okay, so we'll have a good cause adjournment to get a retained counsel on board. We'll set the probable cause conference July 17th at 8:30. Mr. Mask, you should probably make that a priority in getting him retained and then getting him on board. He'll receive discovery once he files his appearance, or some substitution of counsel with the public defender's office. Anything else for the record in 25-01620, Mrs. L?
Not for the people.
Mr. Lee.
Nothing further, Your Honor.
All right, Mr. Mask, we'll see you on that July 17th.
Mr. Cornish, could you please name the defendant one of those passes? Thank you.
And then is this Mr. Lira?
Yes, Your Honor.
All right.
One for you. and one
Oh,
for
no,
me.
one's for the file. Thank you.
Thanks for checking, because the way I'm going today, who knows when scheduled.
No, I didn't think you made a mistake. I was just wondering why, because it was set for prelim today.
Oh, I make mistakes. Trust me, I usually figure them out myself, but yeah, I can screw that up in a hurry.
I'm just saying that wasn't my first thought.
Do you think we'll need Mr. Neves or whoever's covering for him for Mr. Lyra?
I
Because
don't
we can,
believe it's gonna be a contest.
okay,
It will not be a contested hearing.
all right. Right, ma'am, what's your name?
Yara Khalil,
Spell it for me, please.
first name Yara, last name Khalil.
And you're from the Public Defender's Office?
Correct.
Just never been in front of me.
Yes, I just got sworn in earlier this month.
Well, congratulations.
Thank you.
All right, Mr. Lyra, you can come next to your counsel.
Yes, sir. Good morning.
Good morning. We're on the record in docket 23-00120. That is people of the state of Michigan versus Emilio Lyra. Will the parties please introduce themselves for the record, Mrs. L?
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the people.
Ms. Khalil.
Yara Khalil on behalf of Mr. Lyra, who appears to my right.
And sir, you are Emilio Lyra, is that correct?
Yes, sir.
All right, thank you. This is time set for a probation violation hearing or an arraignment. I don't have an arraignment on this.
You were rated by 6.
Yes.
My girlfriend says she will take it. She's my best friend.
All right, so this was set for probation violation hearing. And Mrs. L, how are we proceeding, or would you like to defer to Ms. Khalil?
Your Honor, if I could please defer to Ms. Khalil.
All right, Ms. Khalil, how are we proceeding?
Your Honor, Mr. Lyra will be pleading guilty to the violations.
All right. And so we're making sure that we're working from the same violation. I have have you failed to appear? But I want to see if the violations are. Here we go. Those are all the violations. So are we working on the June 9th violations, Ms. Khalil, or do we have subsequent violations to that?
Your Honor, it was my understanding that there are positive substance violations.
Yeah.
From May of 2023. And
From May 25, 2023.
correct.
Okay, those are the allegations. All right, it is alleged, sir, that you tested positive concerning this matter. This was done by request and summons for a probation violation by Heather Dohosky on June 9, 2023. You understand you have a right to a hearing in this matter, and you are represented today by attorney, I'm going to butcher this name, Yara Khalil.
Perfect.
Okay, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Is that your understanding, sir?
Yes.
All right. It's my understanding it is your wish today to admit to through the violation, which is the technical probation violation. And that would be violation number 14. That doesn't mean there are 14 violations. It's just how we label it. Is it your wish today to admit to violation number 14?
Yes, Your Honor.
I'm going to raise your right hand. Do you solemnly swear or affirm, tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
It is alleged by Heather Dohosky that you tested positive at PATS on May 25th, 2023 for THC at 20 NGs and cocaine at 373 NG and alcohol greater than 100,000 NG on May 25th, 23. Do you admit for the testing positive for THC, cocaine, and alcohol?
Yes, Your Honor.
And you've been able to go through the pre-sentence recommendation with your counsel, is that correct?
Yes.
All right. Allocution, Ms. Khalil.
Yes, Your Honor. After getting to know Mr. Lira, I've been made aware that although we understand the recommendation to terminate probation, he would greatly appreciate the opportunity to continue probation. He's currently living with an extremely supportive partner. His girlfriend is completely substance-free, does not permit him to use substances, and maintains a substance-free household. Additionally, with the support system, he is currently signed up for Alcoholics Anonymous, and his partner has agreed to attend with him to keep him on track. He is also currently pursuing his GED. I see great potential in Mr. Lira to continue to be successful on probation, especially with his maintenance of his sobriety and with these violations being a couple of years old.
Thank you. Anything, do we have a credit, do we have any time do we have a time served on this? I'm just curious with the. And then I'll go to you, Mrs. L, after we figure out the time served. Six days. I have 6 days credit.
I just did, I went to jail last Monday, and then I had like 4 before that. I went to jail last Monday, so that's.
So that's probably the 6, 9.
And then I had 4 when I first got on tether. When I first got the charge 2 years ago, I had 4 days.
All right, Mrs. L, any response?
No, Your Honor, I would like to just say that I think the alcohol and drug testing are a good idea to keep in place here. But we would ask that the recommendation be followed. Thank you.
Right, thank you. I'm going to follow the recommendation, Mr. Lira. It just doesn't seem like probation is a good idea for you at this time. And I give you credit for doing all this on your own, because there may be a problem. I don't know. We don't have any. We have planned but we do know that probation doesn't want to work with you, and you've absconded at some level. I don't have anything new on this case between 2023, June 27th, 2023, and June 24th of 2025. So a couple of years. We lost track of you for a couple of years. So therefore, I'm going to file the recommendation. I'm going to terminate probation. I'm going to sentence you to 20 days in the Ingham County Jail for any credits for time served. I think we have it at 9. It could be different. And then you'll be all set after this. It'll be all done. Probation will be done. And then you can go on your journey in regards to the substance abuse or what have you. But I think it's the responsibility of the court to meet you where you are. And you know that better than we do. So you have to invest in the time. I'm not sure probation is there for you right now.
Yes, sir.
Yeah, but good luck to you. Okay, Mr. Lira?
Thank you very much. I
Thank you.
appreciate you.
All right. And then you said Mr. Christie.
Correct.
All right.
I believe actually the remainder of the cases may be in custody.
All right, so we'll just, I don't know if Megan knows that. Does Megan know that Christie's next? She might have just taken Lyra.
Yes, she does. Your Honor.
Okay. Thank you, Mr. Lee.
How many days jail did you give him?
20,
Credit for-
credit for 9. We had 9, it's credit for. I miss Porter joining us by Zoom.
Oh, okay. Okay.
Couldn't agree with you more.
You want to call it?
Ms. Porter, you're here for your 10 o'clock, is that correct?
Yes, Your Honor.
All right. I'm going to place you in a, I'm going to place you and you're on Zoom, is that correct?
Yes, yes, sir.
All right. You know, you probably should be here for the probation violation hearing. You understand that?
No, I wasn't aware. I thought I was supposed to come via Zoom.
All right. I'm going to give you the opportunity to speak with your attorney in this, your public defender, and then we'll go from there. All right. Once your public defender joins us, we'll place you both in a breakout room. All right, ma'am?
Okay, thank you.
You're welcome. All right, so we're on the record in docket 24-02603. That is people of the state of Michigan versus Curtis Thomas. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Ms. Khalil.
Yara Khalil on behalf of Mr. Thomas, who's present to my right.
All right, and sir, you are Curtis Thomas, is that correct? All right, thank you. This is the time set for a probation violation. Mrs. L, how are we proceeding?
Your Honor, it's my understanding that today will not be a contested hearing. I will defer to Ms. Khalil for more.
All right, Ms. Khalil.
Yes, Your Honor. After speaking with Mr. Thomas, he understands that he tested positive for the use of alcohol. He, however, did recently test about 10 days ago again as part of his probation and was negative on all substances. And he understands how important sobriety is for him. It's a priority for him. He has a great relationship with his probation officer, Mr. Sumter, and he is looking forward to completing the rest of his probation without issue.
All right, so the plan here is to have the admission. Is that correct, Ms. Khalil?
Yes, Your Honor.
All right. All right. May I inquire of your client, Mr. Thomas, of his admission to the probation violation? A
Yes.
Technical PV. All right. So we're working from the same document, or make sure this was filed by Brendan Hanna on June 12th, 2025. And I think he was covering for Joe Sumter, who's on family leave. Is that your understanding? Just so we're working from the same document.
Yes, Your Honor.
All right. That would be violation 13. Of course, that's not 13 violations. That's just how we label them. So that's a single violation. And Mr. Thomas, you understand you have a right to a hearing today. You have a right to counsel. Ms. Khalil is here on your behalf, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that? Yes. It's my understanding it is your wish to waive your right to a hearing and admit to the technical probation violation. Is that correct, sir? Yes. I'm going to raise your right hand. Do you solemnly swear affirm, tell the truth, the whole truth, and nothing but the truth under penalty of perjury? All right. All right, I'm going to bring your attention back, sir. This is on June 2nd, 2025. Did you test positive for alcohol at AberHealth in technical violation of your probation? All right. All right, and Ms. Khalil, you've had the opportunity to go through the probation violation recommendation with your client. Is that correct?
I have, Your Honor.
All right. Allocution, and then we'll go to Mrs. L if you have any comment, and then we'll go to Mr. Thomas. Allocution, although you've already made some of it. Allocution, Ms. Khalil.
Yes, Your Honor. Just to reiterate that Mr. Thomas takes his sobriety seriously. He recently had a fully negative test on June 24th as part of his probation, and he's looking forward to continuing his probation without issue.
Thank you. Mrs. L, any comment you want to make on this case?
Just briefly, Your Honor, we would ask for the recommendation of that 1 time per week testing for 30 days. We believe that if Mr. Thomas is committed to his sobriety, he would be able to pass those tests with flying colors. Thank you.
Mr. Thomas, is there anything you'd like to say to the court before the court passes sentence?
I can't say, I don't know, I never had a negative drug test.
All right. All right, I don't know what the tested for positive, but you understand it's our job to make sure that you're drug free, okay? And that's all Mr. Sumter's doing, you know. And then when you test positive, we see if there's a productive relationship with alcohol or destructive relationship with alcohol. And so you've come and admitted you tested positive. So we're wary now, okay? This is the first violation. I'm going to follow the recommendation indicated. The probation release is in December, so I think that's fine. The request by Mr. Sumter is AberHealth 2 times a month, which we'll continue with. That should give us an idea of So I'm gonna follow the recommendation of AberHealth 2 times a month. Start out as a. So this started out as a high BAC case also. So you understand the nature of it, okay? Looks like he wants to add 1 time per week PBT urinalysis for 30 days. I think that's a fair. So 1 week, 1 time per week. PBT urinalysis for 30 days, for the first 30 days. And you can talk with Mr. Sumter about that. He should be back by now. If not, Mr. Hannah is covering his cases.
It's on the 11th.
Okay, all right. On the 11th? Okay. All right. We'll continue probation at this time. I'm not, jail's not suggested, so we're not going to recommend to jail. Right now, it's your chance to show off, okay? You get to come in, you get to say, like, I'm clean, continue being clean. So probation, it comes in December. If there's a future problem, you know the problem, okay? The problem's going to be with alcohol and your testing and any relationship you have with that. It sounds like you have a good relationship with Mr. Sumter, so good luck to you, okay? All right, thank you.
Yeah.
And then if you join, we'll just stick you in a room with Ms. Porter.
Sounds good.
Okay.
Judge.
Is that Mr. Dillon working?
I don't know.
That I don't know.
Are we discussing Mr. Delamarter?
What's that? Yeah.
Mr. Delamarter.
Yeah, did you want to
Yeah, I
cover?
don't know if Mr. Etheridge is still in the courtroom, but I can fill in.
All right.
I don't know if it helps. I didn't have witnesses here to begin with, so I don't have witnesses still. I
Okay,
don't know if that.
I
helps.
can't go look for him either. 'Cause I gotta
yeah,
in custody.
I'm willing to stand in, Your Honor.
all right, let's, Mr. Delmar, you can come up here. So we issued, so we're on the record in 25-01-608. That is people of the state of Michigan versus Mark Delamarter. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Mr. Austin.
Thank you, Your Honor. Good morning. Jared Austin appearing on behalf of Mr. Delamarter. He stands present to my right, filling in for counsel of record, Mr. Etheridge.
All right. This is time set for a preliminary examination. Mr. Delamarter, you were really late, okay? And so we were remanding you. We've already issued the warrant, okay? For the fail to appear. It was set for 9 o'clock. At 10:15, we called the case. You were not here. I can take off the bench warrant, at least do that. Mrs. L, how did you want to proceed?
Your Honor, at this time, the people do not have witnesses here to move forward with the preliminary exam. To be transparent, those witnesses were not here this morning either on time. That witness is a one singular LPD officer. However, I have not had reason as to why he was not here today. We would ask for a brief reset of this case to get that officer here. We understand defense may be making a motion.
All right, thank you. It's law enforcement. All right, Mr. Austin.
Yeah, yes, thank you, Your Honor. Regarding Mr. Delamarter's failure to appear, if the court hasn't made the determination already, I would respectfully request that the court not go forward with the bench warrant on Mr. Delamarter. My understanding is that he was in communication with his attorney saying that he was running late this morning. So he communicated that to somebody, and he has shown up, albeit late, but he has appeared. So I would respectfully ask the court not to take any action against him since he has appeared, albeit untimely, but it sounds like he's having some transportation issues. As it relates to the issue of the preliminary examination, Your Honor, given that the witnesses have failed to appear, doesn't sound like that there's been any communication or any good cause for that failure. I would ask the court to dismiss the matter.
All right, I'm not in a position, I'm not going to dismiss the matter since Mr. Delamarter, we have an issue with so what I'll do is Mr. Delmarter, you failed to appear on June 20th also, so this is the second failed to appear. I don't know how that failed to appear changes the waiver of the 21-day rule. I think that,
Once he fails to appear.
yeah, I think that's,
he's
it's
always
off.
right.
So let's reset this. So let's quash the bench warrant. Okay, we'll quash the bench warrant. So we'll quash the bench warrant and we'll reset the preliminary examination. And then if law enforcement fails to appear on that date, then you can make the motion. It's a viable motion. We're 1 day before the holiday, so there's going to be all kinds of reasons why, but we will quash the warrants. Try your best to be on time. I had you remanded, so that means there is no your warrant and you're remanded to jail, and then you just await you await your you await you're on, and that's very different from the PR bond you were on. So you understand that. We're going to quash the warrant, and we'll reset this for prelim for subpoena purposes for. I don't think we need a PCC. I think we can go to prelim and then it's like one witness.
July 24th at 8:30.
Okay, it'll be July 24th at 8:30. All right, so Mr. Delmarter, you'll get notice from my court officer that July 24th at 8:30, we're quashing the bench warrant. That'll be next time to show up by 8:30 for that preliminary examination. All right. Okay. Anything else for the record in 25-01608, Mrs. L?
Not for the people.
Mr. Austin.
Nothing additional, Your Honor.
All right,
Thank you.
thank you for appearing today on behalf of Mr. Eldridge.
Happy to do it, Your Honor.
I couldn't help but hear the question asked, and it's a very good possibility that if he'd been here this morning, that case might have been dismissed. May have, but he wasn't, so we don't have to worry about that. All right.
Better than going to jail, though.
It is much better than going to jail. This is Mr. Winston.
Mr. Winston.
Okay. All right, Mr. Winston, you can come up here. All right, so we're on the record in docket 25-00818. That is People of the State of Michigan versus Arnold Winston Jr. 25-00848. What did I say?
Not that. Yeah, I think you have the one below there.
Right, so we're on the record in 25-00848. That's People of the State of Michigan versus Arnold Winston. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Mr. Austin.
Thank you, Your Honor. Good morning. Jared Austin, appearing on behalf of Mr. Winston. He's present with me at council table.
And sir, you are Arnold James Winston Jr., is that correct?
Yes, Your Honor.
All right, thank you. This is the time set for a preliminary examination today. Mrs. L, how we proceed?
Your Honor, at this time, the people are ready to continue with that preliminary exam. We have one witness to call today, and that is, one second. That is Deputy Anya Bright. I'm sorry, Bright Anya. Keep doing that to myself. We are ready to continue with calling that witness, Your Honor.
All right, are there any pretrial matters to come to the court's attention on this file, Mr. Austin?
Just one, Your Honor. The court knows this is a continuation of the preliminary hearing when we were here last. Mr. Hayes from JSG Monitoring was here and testified. He testified about some type of user agreement regarding the tether between the company and Mr. Winston. He did not have that with him that day. As of today, that I've never seen that. That's never been provided to us. So given that, Your Honor, I would just ask for any testimony regarding that user agreement be stricken and not considered. Or if the court is not inclined to do that, then I would ask that it not be considered as substantive evidence.
Mrs. L. I can't remember what was, if he quoted from the agreement. I think it was just usually the policy is to get into an agreement with the person concerning the monitoring device and their responsibilities.
Correct, Your Honor. And I do believe that is all that was testified to, was that an agreement was signed, not anything related to the substance of that agreement. It was simply Mr. Hayes describing the process that was taken at the hospital when the tether was placed.
All right. So I don't think that would be used for any substantive measure for the charges concerning. There's the testimony was that the tether went off and that started the process. With that understanding, the sequestration order is still invoked. So if anybody who has the potential for being a witness should leave the courtroom, and I'll leave it to counsel to tell me if there's the potential for anybody to that may be a potential witness. Will invoke sequestration at this time. Hearing none from either counsel, the witness, you may call your first witness, Mrs. L.
Thank you, Your Honor. At this time, the people call Deputy Bright on me to the stand.
All right, Deputy, you can come forward and please, you're going to spell your first name and your last name for the record. So what's your first name and last name?
Bright Onye, BRIGHTONYE.
Please raise your right hand, sir. Do you solemnly swear affirm, tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
All right, have a seat. The microphone goes right to the court recorder's ears, so please project as best you can. And
Yes,
Mrs. L, when you're ready, and let's turn off the fan just so. All right, you may proceed, Mrs. L.
Thank you. Thank you for being here today, Deputy. If I could just start by asking, where are you currently employed?
With the Ingham County Sheriff's Office in Mason
And what is your current position there?
as a corrections deputy.
Thank you. And do you recall working on March 19th of 2025?
Yes, ma'am.
And on that day, do you recall being at a hospital?
Yes, ma'am.
And do you recall what hospital you were at?
Yes, ma'am.
Which hospital was that?
At Sparrow Hospital.
Thank you. And when you were at Sparrow Hospital, do you recall who you were there with?
Yes, ma'am.
Who was that?
Mr. Winston Arnold.
Thank you. And is Mr. Winston Arnold or Arnold Winston in the courtroom today?
Yes, ma'am.
And could you please just describe something that he is wearing?
He's wearing a neck bracelet with a geo jumpsuit, color blue.
Thank you. Your Honor, at this time, the people would ask that the record reflect that Mr. Winston has been identified for purposes of prelim.
Any objection to the witness identifying the defendant for purposes of prelim, Mr. Austin?
Without objection.
Without objection, the witness has identified the defendant.
Thank you. And while you were there with Mr. Winston, what did you observe? Was a tether placed on?
Yes, ma'am.
Object deleting.
I can, that was a, yes,
We'll have you
Your Honor, I
rephrase.
apologize.
The objection sustained.
Could you describe what you saw when you were with Mr. Winston?
When I was with Mr. Winston at the Sparrow Hospital, the tether company, GSG, I believe his name is Tom. He came in and placed the tether on Mr. Winston.
And at that time, do you recall why Mr. Winston was in custody?
No, not actually. I don't know why he was in custody.
Okay.
He was under custody in jail.
Thank you. No further questions, Your Honor.
All right, cross-examination, Mr. Austin.
Just a moment, if I may, Your Honor. Thank you, Your Honor. I have no questions for the deputy.
All right, may this deputy be excused from the people, Mrs. L.
He may, Your Honor.
All right, thank you for your appearance today, sir. You're all excused. All right, any further witnesses today, Mrs. Dell?
No, Your Honor, the people rest.
All right, any proofs today, Mr. Austin?
We'll rely on the evidence presented, Your Honor. Thank you.
All right, thank you. Motion for bind over.
Thank you, Your Honor. Today, Mr. Arnold Winston comes in front of you charged with 3 counts of absconding from bond, 1 count of tampering with an electronic monitoring device, and a habitual 4th offense. At this time, Your Honor, the people believe that we have met by a probable cause standard, that Mr. Winston was on bond at the time that he was at the hospital, and that he was on bond for multiple cases. We also believe that we have laid the probable cause foundation and evidence for tampering with the electronic monitoring device, as the electronic monitoring device was seen being placed on Mr. Winston at Sparrow Hospital by Deputy Anye, and then was notified, JSG was then notified that it had been cut and left, and was later found by another deputy, I'm sorry, Deputy Brad Delaney. And Deputy Delaney did testify that he found that cut tether in a garbage can later that day. And it was the same tether that was being, that was tracked to, or that was placed on Mr. Winston. At this time, Your Honor, we would ask for bind over on all counts. Thank you.
Response to the motion for bind over, Mr. Austin.
Yes, Your Honor, thank you. Kind of working backwards here, a little bit, starting with the main 3 counts that I'm going to be addressing, which are the absconding counts, Your Honor. I'm going to be opposing the bind over on all the counts, but I wanted to start first with the absconding count. I know in the people's motion for bind over, they were very brief, essentially stating that they believe that they had met their probable cause burden, that Mr. Winston was on bond for multiple matters. They didn't go into detail about what that evidence was or what evidence was presented to the court. And I think the reason is because it's my position is that there wasn't it, or at least there is a great deficiency in the proofs of, if any, that were presented on those key elements that they have to prove for absconding. As far as I can tell, Your Honor, there is a jury instruction on point for the absconding charges. That would be the model jury instruction 13.17. A few things I think to note on that, Your Honor. The title of it, absconding on a bond. And the very first thing that is stated in that jury instruction, the defendant is charged with the crime of absconding on a bond posted in a criminal case. I think that is a very clear distinction on what this statute seeks to prohibit and what the people have to prove at this stage by a probable cause burden that it has occurred. Even assuming that the people have demonstrated to the court that Mr. Winston was on bond or subject to bond conditions, and I'm not necessarily conceding that, but they have to show that, according to this, that he had a bond posted. That's why it's called absconding on a bond. For example, I think the plain reading of that instruction, the plain reading of the statute, I think it is clear. For example, if Mr. Winston had a bond that he had posted, whether that's a recognizance bond or whether that's some type of cash bond, and that he then willfully does not follow through with his obligations, such as appearing for court and so forth, he may very well be guilty of that particular offense. But assuming that there was evidence presented here that Mr. Winston had a bond, there has not been any evidence presented that he had posted that bond, which I think clearly the law, the statute, and particularly the jury instruction for those charges requires. They have not presented any evidence of that bond or those bond conditions, Your Honor, which they have to show. They have to prove. The court can't just assume that or just can't infer that from the testimony. They have to offer some proof of that. And it wouldn't necessarily have been that difficult to do. They could have provided some type of certified documentation from the court files of those bond conditions, which was not done in this case. There was no recitation of those bonds or of those specific bond conditions by any witnesses presented at either sessions of this preliminary examination. We didn't hear any testimony from any witnesses, such as the arraigning judge or magistrate that perhaps set those bonds, which again, they easily could have done. And there also has to be, not only do they have to prove those things, they have to offer some evidence as to exactly what Mr. Winston was prohibited from doing, and then what he failed to do as it relates to those bonds. Again, we haven't had any evidence of that. And the second element, that the defendant was informed that he could not leave the state without permission of the court. I don't think they're operating under that theory. There hasn't been any evidence that would suggest that. Without permission of the court, and that the defendant had to appear at all scheduled court dates unless otherwise directed by the court. Again, we don't have any evidence of that. We don't have any evidence of those bond conditions. We don't have any evidence that he was informed of that. They have to prove that. And again, that's just not something the court can infer that, well, he's in a hospital, there were deputies there, he must have been on a bond, he must have been notified he had a bond. Those are elements, key elements that they have to prove. And there just simply has not been any evidence or testimony of that. And the third thing that they have to prove is that the defendant absconded on bond. Abscond means to leave the state of Michigan or to hide or conceal oneself. Again, I don't think it's without dispute that I don't think anyone's alleging that Mr. Winston left the state. There certainly hasn't been any evidence presented on that or that would suggest that. But I would argue there's a deficiency in the proofs that he was hiding or concealing himself in an attempt to avoid the legal process or reckless disregard of a known obligation to appear. That's something that they have to prove. And again, we don't have that as record evidence at this hearing. We don't have record evidence of a bond. We don't have any record evidence of what those bond conditions were for each of those three separate counts. We don't have any record evidence that he was ever informed of this bond or whatever these bond conditions were. So given that, Your Honor, I think there is a great deficiency on the proofs as it relates to counts 1, 2, 3. And I would certainly ask the court to deny the people's motion for bindovers relates to that. And again, I think the clear reading of, I think not only the statute, but particularly the jury instructions is that it has to be a bond posted in a criminal case. Not only is there a lack of proof of a bond in this case, Your Honor, there's been zero evidence to suggest that Mr. Winston had posted a bond in any of these counts. So I think the proofs as it's been presented at this hearing are certainly deficient as it relates to counts 1 through 3. I would ask the court to deny the people's bindover for that. I'm really not going to argue much as it relates to count 4, as it relates to the tampering of the electronic monitoring device. I think the court has seen and heard the testimony on that. I'm not really going to make an argument on that other than to say I oppose the bindover on that as well.
All right, thank you. Response, Mrs. L.
Just briefly, Your Honor, we do believe that we've met a probable cause standard, that there was an agreement made. That agreement included not cutting that tether. That agreement meant he had to appear for scheduled court dates. There was no bond posted at this time, as it seemed the tether was placed specifically for medical purposes. So that bond was not posted. However, the defendant did remove his tether and did conceal himself. And I will say, Your Honor, it does sound, based on the testimony today and the testimony on a prior day, that was all done with the intent to avoid the legal process. However, Your Honor, we leave it to your discretion on those counts. Thank you.
All right,
Your Honor,
thank
may
you.
I just have a brief response to that?
All right, Mr. Austin.
Thank you, Your Honor. The first part regarding the evidence about the tether agreement, that was the entire subject matter of my initial motion before we started the session today. That was my concern about that, because now they're arguing that the court treat that as substantive evidence about any testimony about his obligations as it relates to the tether. And the court had indicated earlier that it would not consider that for substantive evidence, but yet that's what the people just now got up and argued. And again, Your Honor, it just sounds like they're making an argument based on on inferences, and there is just not enough or really any record evidence on these very key elements that they have to prove for the absconding charges for the court to infer. Again, these are elements that just cannot be reasonably inferred. They have to prove. And again, there's been no evidence presented of what these bond conditions were, that the bond was posted as is required, and per the jury instructions. No evidence presented that Mr. Winston was informed of. Thank you.
Thank you. The standard for preliminary examination is probable cause. Probable cause being the second lowest standard in criminal law, reasonable suspicion being a lower standard. I believe probable cause is met as to location, which is Eureka Street and homes in the city of Lansing for counts 1 through 4. In Ingham County, so that'd be location, venue, and venue on both of those. The date is of March 19, 2025. That's been proven by probable cause evidence. So location, venue, and date. Identification was made today by the deputy. So ID is made. And so whether we have the offense of the elements at a probable cause standard, what we have here is that the defendant was on bond. We know that because he has to get a tether. And that's part of and for whatever reason, I don't know what the reasons are. It appears they may have been medically related, but that the tether was placed on him. And JSG through John Hayes, who was the first witness, indicates that this is the process of the tether monitoring system. It would appear that as a part of that process, JSG reported that the defendant had left the hospital, that the device is located at a trash can. It was later verified by Sergeant Delaney that the device was at a trash can, and that and then we have the identification as the individual. In regards to the bond and absconding or forfeiture, at a probable cause standard, it is met that he was on bond for counts 1, 2, and 3 in relation to the GPS that someone removed. The allegation is he removed it through JGS monitoring system. I don't think anybody was there and watched him removed it, but it was on him. It was a part of the process. He was on him, and it was removed. And then it was found at the trash can by Delaney, by Deputy Delaney. I'd find that at a probable cause level, the standard has been met in regards to counts 1, 2, and 3 for a bond for absconding or forfeiting, and then count 4 tampering with electronic monitoring device. That's very inferential in that he is the person who tampered with the device that was ended up being found. The device was seen placed on him, and then it was removed from him. The middle of the road it was monitored and removed from him, and then it was found later. It all relates to Mr. Winston. I believe that's found at a probable cause level, and I will bind over as charged at the probable cause level on counts 1, 2, 3, and 4. That's 3 counts of absconding on bond and 1 count of tampering with electronic monitoring device. I will indicate the examination was held on today's date, which is July 3rd. And I will indicate it was bound over as charged. So, Mr. Winston, your time in district court is done. You're bound over to circuit court. You'll get your next date to appear in circuit court from Mr. Austin, your attorney. Decision was made based on 3 witnesses' testimony in the adjourned preliminary examination. Anything else for the record in docket 25-00848, Mrs. L?
Not for the people.
Mr. Austin.
No, Your Honor, thank you.
All right, so you'll get your next date from Mr. Austin, your attorney. Mr. Winston, you should be all set. Thank you.
Do either of you want the transcript?
Yes, please.
Yeah. That's your stuff.
you want us to get Mr. Johnson?
Yes.
That's the next one. And then Ms. Khalil, are you ready on? We did Mr. Thomas. On Ms. Porter.
Yes, Your Honor.
We're going on Mr. Johnson. All right, Ms. Porter, we'll call your case. So we're on the record in docket 20-401-795. That's people of the state of Michigan versus Michaela Porter. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the people.
Ms. Khalil.
Yara Khalil on behalf of Ms. Porter, who appears by Zoom today.
All right. And ma'am, you are Michaela Porter, is that correct?
Yes, Your Honor.
All right, thank you. This is the time set for a sentencing or for a probation violation hearing in the matter. Mrs. L, how are we proceeding? Or would you like to defer to Ms. Khalil?
I would like to defer to Ms. Khalil. Thank you.
Your Honor,
Ms. Khalil.
yes, the violations will not be contested.
All right. All right, violations are not contested today. And so we're working on the same. That is, it is a one violation on 2 dates. And it's for June 13th, probation officer is Brendan Hanna. Is that the same allegation?
Yes, Your Honor.
Okay. Just want to make sure.
No.
All right. So we're on the record, and so that is, I want to make sure number 13. I want to make sure it's what we arraigned you on to. July 10th. July 13th. That was 13, all right. All right. All right, so they inquire of your client, Ms. Porter, of some advice of rights that she has in this case, and then her technical probation violation. All right, Ms. Porter, you understand you have a right to at a hearing in this matter. You have the right to be represented by counsel. You are represented today by attorney Yara Khalil, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, ma'am?
Yes, Your Honor.
All right. You understand that the allegation is a technical probation violation listed as violation number 13. And it is my understanding, it is your wish today to waive those hearing rights and plead to the technical probation violation. Is that correct, ma'am?
Yes, Your Honor.
All right. All right, I'm gonna have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do, Your Honor.
All right. All right. This is listed on Brendan Hanna, request and summons for probation violation on March 11th, 2025. It is alleged that you tested positive for alcohol on February 19th and February 21st in technical probation violation of your probation. Do you admit to testing positive for alcohol on February 19th and February 21st, ma'am?
Yes, sir.
All right. All right. So I find that the admission probation violation be knowing, voluntarily, and accurately made. Ms. Khalil, have you had the opportunity to go through the probation violation recommendation with your client?
I have, Your Honor. I just wanted to note that the probation violation documents my office received were for positive alcohol testing on May 30th and June 2nd of this year. I believe the February violations were for a separate violation hearing.
Yeah, that was my I have a a hearing on, so is this not an up-to-date recommendation, or would we want a second an up-to-date? Because this has June 13th is the date for the probation violation recommendation. And then this was on for March. For June, see, I've got March probation violations that I believe were pled to on April 1st. And then that would make the June were pled to today. Is that your understanding, Ms. Khalil, or do we need an updated report?
I have an updated report. We just received it yesterday from probation.
Okay, does that have the date June 13th on it?
It does. And it's for testing positive for alcohol at AverHealth on May 30th and June 2nd this year.
May 30th and June 2nd.
Correct.
Okay, that's the one she just pled to. All right. No, I've got that. I've got May 30th and June 2nd. That's what she pled to. That's from Mr. Hanna, who did the recommendation. Did you want to have a sentencing hearing on that? Do you have any questions of Mr. Hanna concerning the recommendation? We're on Zoom and it makes it hard to have a hearing, or at least a sentencing hearing if you wanted to, because there is some recommendations concerning a sober link and a 12-step. He does highly suggest jail, and Mr. Hanna would be here if we set up for sentencing to explain to you why he's suggesting that, and then to give you the opportunity to argue against that. It's entirely up to you, but that would also require Ms. Porter to be here for the sentencing. It's up to you.
Your Honor, I've had a chance to discuss the recommendations of Mr. Hanna with Ms. Porter, and if I could just be heard on those recommendations.
Sure. All right, allocution for the recommendation violations, Ms. Khalil.
Thank you, Your Honor. I would like to note that while Ms. Porter, of course, takes responsibility for these violations, I'd like to provide an explanation rather than an excuse, of course. Just wanted to note that she does have a dental surgery scheduled for next month. And as ordered by her dentist, she was instructed to purchase a specific mouthwash that has an alcohol content of 15% and to use it twice a day. After speaking with Ms. Porter about how any alcohol ingestion is contrary to her probation, she understands that she either needs to call her dentist and get documentation that she can show her probation officer that she is instructed to take, and she would also use an alcohol-free mouthwash until she gets such documentation. She is also extremely open to the Scram Tether effective immediately and the 12-step meetings as recommended by Mr. Hanna. And to the best of my knowledge, Ms. Porter hasn't tested positive for any substances since June 2nd, and she does test once weekly. I would also like to note regarding the weekend in jail recommendation that Ms. Porter is a single mother. She has 4 children. She is the sole caregiver for them and does not know who would be able to look after her children if she were to go to jail, and she would also potentially lose her job. Something she's doing in the meantime to maintain a good journey in her probation is meeting with a therapist weekly, and she actually gets a new therapist starting next week, so there will be no discontinuation in her mental health journey. And that is all I have to say on behalf of Ms. Porter.
All right. Anything towards the sentence of Mrs. Ellen?
No, Your Honor, we would leave this to your discretion. Thank you.
All right, thank you. Ms. Porter, is there anything you'd like to say to the court before the court passes sentence on your violation of probation?
No, Your Honor, she explained it perfectly.
All right. All right, Ms. Porter, you kind of understand the deal here. This is your second technical violation, and we're trying to figure out if you have a productive or destructive relationship with alcohol. And right now, based on 2 violations, you're testing positive for alcohol. And for whatever reason, that doesn't bode well for you. You understand that? Ms. Porter, you
Yes,
understand
Your
that?
Honor.
You also, this
Yes,
is,
Your Honor.
this should be a live hearing and you're attending by Zoom, so that's problematic. Do you understand that, ma'am?
I understand.
All right, so you understand that I'm gonna follow the recommendation, but I'm with a little tweak to it. But you understand that, I mean, you've already got 2 probation violations. If you test the 3rd positive alcohol violation, you understand that it's problematic. That we're really starting to wonder if there's a destructive relationship with alcohol, because it appears on probation you can't stay away from alcohol, and that becomes a problem. And I know you have some behavioral excuses indicating why, but the continuation of the violations speaks for itself. You understand that?
Yes, Judge.
All right. I will follow the recommendation with one tweak. The treatment will be at Samaritas Outpatient and Mental Health Counseling. So I'm following the recommendation. With one tweak, it'll be, testing will be at AverHealth 1 time per week. I'm going to continue termination. The probation termination date would be in October of 2025. We're going to add a SoberLink scram for 120 days. That would be the remainder of probation, I would think. 12-step meetings 2 times per week. I'm going to have a weekend in jail held in abeyance. So essentially, Ms. Porter, I'm taking that weekend, that highly suggested weekend from your probation officer, and I'm just holding it, okay? So you'll have you won't have any jail time. I'm just holding it. But if there's another dirty drop, that'll be added on to whatever time for the dirty drop. It'll be 2 days plus. Do you understand that, ma'am?
Yes, Your Honor.
All right. So please so I'm following the recommendation. Please keep in contact with Mr. Hanna. The court's pretty aware that Mr. Hanna is a pretty flexible guy. He kind of he'll kind of meet with you and let you know what you're doing. But right now, Ms. Porter, I'm not concerned about where you're going to be till October. I know you're going to be on probation with me, and I know that we're going to have some oversight concerning your drops. I'm more concerned about, Ms. Porter, 2 or 3 years from now, where you've got to make good decisions based on a foundation of good decision making. And I'm worried about it right now because you've been on probation for drunk driving, essentially, and you're not unable to stay away from testing positive for alcohol. That is a huge red flag to me. Do you understand that, ma'am?
Yes, Your Honor.
All right. Please keep in contact with your probation officer, Mr. Hanna. I'm following the recommendation, but I'm holding the 2 days in abeyance. Ma'am, you should be all set. All right.
Thank you, Your Honor.
All right. Anything else for the record in 2401795, Mrs. L?
Not for the people.
Ms. Khalil.
No, Your Honor.
All right. You're all set. Thank you.
Thank you.
And then Mr. Johnson.
Correct, Your Honor.
Yes, Your Honor.
Right, so Mr. Johnson, you can come up here when you're able. So we're on the record in docket 2501766. That is People of the State of Michigan versus Tyreen, I would correct my pronunciation, Tyreen Johnson. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Lizelle, Assistant Prosecutor for the people.
Mr. Austin.
Your Honor, good morning. Jared Austin, appearing on behalf of Mr. Johnson. He's present with me at council table.
And sir, you are Tyreen Johnson, is that correct?
Yes, sir.
All right, thank you. This is the time set for preliminary examination day. Mrs. L, how we proceed?
Your Honor, at this time, the people have witnesses present and are ready to proceed on this preliminary exam. We have 2 officers to present today, Officer Mark Fox and Officer William Traverso, both of Lansing Police Department.
All right, is there anything, and is that a fair statement, Mr. Austin? And is there anything to come to the court's attention before we start the preliminary examination, Mr. Austin, and do you want me to invoke sequestration?
Yes, Your Honor, I would motion the court for that, please.
All right, we'll invoke sequestration. So no witness should watch another witness testify. I'll leave it to counsel who knows the case better to bring that to the court's attention. But if I have to invoke and sequestration is invoked, so I may remove you from the courtroom if another witness is testifying. With that understanding, Ms. Azell, anything to come to the court's attention?
Just that I misspoke briefly, just moments ago. It is not Officer Traverso, it is Officer William Turbo. I apologize. I did get those names mixed up in my head.
All right, are you ready to call your first witness, Ms. Azell?
We are, Your Honor.
All right, the people may call their first witness.
Thank you, Your Honor. At this time, the people call Officer Mark Fox to the stand.
All right, Officer Fox can come up here. I'm gonna have you spell and state you can stand right there and you can spell and state your first name and last name for the record.
Mark, M-A-R-C, Fox, F-O-X.
All right, please raise your right hand, sir. Do you solemnly swear, affirm, tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, you can have a seat. As you know, the microphone is for recording purposes, so please project as best you can. And Mrs. Zell, when you're ready.
Thank you, Your Honor. Thank you for being here today, Officer Fox. If I could just start by asking, where are you currently employed?
Lansing Police Department.
And what's your position there?
I'm a police officer, a patrol officer.
And were you working on the date of June 14th, 2025?
I was.
And what shift were you working that day?
Third shift.
And while you were working, did you receive a dispatch to 526 South Chestnut?
I received a dispatch for a fight at 526 South Chestnut.
Thank you. And did you respond to that location?
I did.
And when you responded to that location, what did you observe?
As we were entering the building, I observed a male who fit the description given by dispatch, walking south on Chestnut in front of the building. My partner followed him for a second on foot, said, "Hey, that's probably him." I got in my patrol vehicle. I went around the block, west on Hillsdale to South Pine. And I made contact with the accused on the corner of Hillsdale and South Pine.
And do you recall what that description was?
It was a light-skinned black male. He was shirtless in the description, and he was arguing with a female, and the fight may have gone outside as we were arriving.
And when you were, you said you got in your patrol car and you made contact with the accused, could you describe what he looked like at that moment?
Dark colored pants, no shirt.
Thank you. And what information did you gain when you made contact with the accused?
So, as I stated earlier, I suspected it was the accused. So I initiated an investigatory stop. He was on foot. I shined my spotlight on him from my fully marked patrol vehicle. I got out of my vehicle. I said, "Hey, come here. I need to talk to you." And he immediately started running north on South Pine.
And just to back up a little bit, what were you wearing that day?
My full uniform.
And so you asked him to stop, told him to come to you. What happened after that?
He immediately started running north on Pine. I want to say approximately a quarter of a block. He ran face first into a chain link fence and hit the ground. I jumped on top of him, and because he was shirtless and sweaty, my hands slipped off. I grabbed onto the back of his pants, and he pulled me 180 degrees, twisting my knee, and then ran south on South Pine, cutting across Hillsdale, around the Fox 47 building, where he was taken into custody by my partner.
Okay, and you said your knee got twisted there.
Yep, I sprained my knee. I was out of work for 4 days.
And after this incident, did you receive medical attention for that?
I went to the Okemos ER,
And you said you were out for 4 days.
4 days.
How does that injury affect you today?
My knee still hurts today. I'm probably gonna have to have a surgery later on my meniscus.
Thank you. And before this instance, did you have any issues with that knee?
No,
And did you injure your knee after this incident at all?
no.
No further questions at this time.
Cross-examination, Mr. Austin.
All right, thank you. Morning, officer.
Good morning, sir.
So as I understand, you were being dispatched to the area for a fight or possible fight. Is that right?
Correct.
Okay. And the description that you gave earlier, I believe you said light skin, black male, shirtless, and possibly arguing with a female. Is that, did I understand that correctly?
I believe those were the dispatch notes.
Okay. And was that the extent of the description as far as you can recall?
No, I knew that initially the fight was in apartment 21 and it was a male and a female, and the fight had gone outside, possibly had gone outside for dispatch, as it was updated as we were arriving on scene.
Well, I guess more important with my question as far as the physical description of the person or persons you may be looking for was the extent of what you just testified earlier.
I don't.
Okay. Well, the description provide any type of age of the person that you can recall?
I was a younger black male. I knew we were looking for not an older person. We're looking for a younger person.
And their description and anything involving the hair of the individual?
Not that I recall.
Thing involving any type of like facial tattoos, glasses, no glasses, anything like that?
Not that I recall.
And any particular description about the female that may be involved?
Not that I recall.
And you did not, when you arrived in that area, you said you just saw the shirtless male walking. Is that correct?
So my partner and I, Officer Billy Turbo, arrived on scene, and I saw a light-skinned black male with no shirt walking by, and I said, "Hey Turbo, do you think that's him?" Turbo got out behind him and walked right behind him for a second, looked back at me, said, gave me the head nod that he thought it was him. Then I got in my patrol vehicle to go stop him for an investigatory stop.
Well, I guess my question is that you did not see anyone else other than this shirtless black male. Is that correct?
No, no one else was walking down the street.
Okay. So there was no female there, correct?
I did not see one, no.
Okay. You did not see or witness any type of fight or arguing, is that correct?
I did not.
Okay. And you said the person that you saw, he was just walking, is that right?
Yes.
At a normal pace?
I guess so.
Okay. Wasn't running or anything like that, in other words, when you
not at the
saw
moment
him.
that I saw him as we were entering the building. He was not running, he was walking down the sidewalk.
And so in your mind, you were there to detain him to investigate this possible fight then, is that correct?
Correct.
Okay. And I know you talked about some subsequent actions that happened after you initially spoke to this person, but when you initially arrived on scene, saw the person walking, safe to say you had not witnessed him commit any type of crime at that point, is that correct?
No.
And I guess just another point of question of clarification, if I may. And you you said you had first asked this individual that you had wanted to speak with him or something along those lines. Is that correct? I need to talk to you or something like that?
I said, hey, come here, I need to talk to you, something
Okay.
like that.
Okay. All right. Thank you, officer. That's all the questions I have.
Any redirect of Ms. Azell?
Just briefly, Your Honor, Officer Fox, you said this happened, or you were initially dispatched to 526 South Chestnut, correct?
Correct.
Is that in the city of Lansing
It is.
and in the state of Michigan? And when you first spoke to the suspect that you had seen, did you tell him at all that he was being detained?
I don't think I said the word, you're detained, but I said, hey, come here, I need to talk to you. I was in essence detaining him for my investigation.
Did you give him a reason at that point of why you needed to talk to him?
I didn't have the opportunity. As soon as I put my spotlight on him, he got out of my car and said, hey, come here, I need to talk to you. He immediately ran away from me.
Thank you. No further questions.
May this witness be excused from the people,
He may, Your Honor.
from the defense.
Yes, Your Honor.
You're all set, sir. Thank you for your appearance today. And you may call your next witness, Mrs. Zell.
Thank you. At this time, the people call Officer William Terrabell to the stand.
Right, Mr. Officer Turbo, you can come up here. And I'm gonna have you spell your first name and your last name for the record.
First name William, William, last name Turvo, Tervo.
Please raise your right hand. Do you solemnly swear affirm to tell the truth, the whole truth, nothing but the truth under penalty of perjury?
I do.
Right, go and have a seat. The microphone, as you know, is for the court recorder, so please project as best you can. And Mrs. Zell, when you're ready.
Thank you for being here today, officer. If I could just start by asking, where are you currently employed?
Lansing Police Department,
And what's your current position there?
police officer,
And how long have you been in that position?
just over 4 years.
And were you working on June 14th, 2025?
I was,
Do you recall what shift you were working?
night shift.
And on that day, were you dispatched to 526 South Chestnut?
I was.
Do you recall what that dispatch was for?
It was reports of a fight, but also we had information that the person known to live there was wanted by the Michigan State Police.
And do you recall what that name was?
Yes,
And who was that?
Tyrion Johnson.
And at that point, were you familiar with Mr. Johnson?
I've never had personal contact with him before, but I ran him in our systems.
And did you respond to that address?
I did.
When you arrived at that address, how did you proceed?
I tried to get in the building.
And were you successful?
I was not.
When you were unsuccessful, did you observe anything?
Yes, Officer Fox said he saw a male walking down the sidewalk. I turned and looked and saw who I believed was Tyrion Johnson.
And why did you believe that was Mr. Johnson?
Skin complexion was the same. I saw like the side profile of his face, and after looking at his photo, I believed it to be the same person.
Thank you. And would you recognize Mr. Johnson if you saw him again? And is he present in the courtroom today?
Yes.
Could you describe him by something he's wearing?
He's wearing the blue jail jumpsuit and some clear glasses.
Thank you. Your Honor, at this time, the people ask that the identification of Mr. Johnson be placed on the record for purposes of prelim.
Any objection to the witness identifying the defendant for purposes of prelim, Mr. Austin?
Without objection.
All right, without objection, the witness has identified the defendant.
Thank you. Once you saw Mr. Johnson, how did you respond?
He was walking away from us on the sidewalk. I walked towards him. Once I got to the corner where he turned, he was too far down the other sidewalk, so I went back to my patrol car to try to catch up.
And at this point, what were you wearing?
The full patrol uniform.
And what patrol car, and I'm sorry, let me rephrase. What did your patrol car look like?
Fully marked.
When you went back to your patrol car, How did you proceed from there?
Once I got to my car, Officer Fox stated he had him running from him, so I responded lights and sirens to where they were at.
When you got to where they were, did you exit your vehicle?
I did.
What'd you do after exiting your
I
vehicle?
began to chase after Mr. Johnson on foot.
Were you able to catch up to him?
I was.
And while you were chasing him, did you give any verbal commands?
I did.
What verbal commands?
Told him to stop, and I also told him that he was the tased.
And how many times did you warn about the tasing?
I believe just once.
And was the taser issued?
I attempted to, yes.
And was it successful?
Only one of the probes connected, so it was not deemed a successful.
Once that probe hit, were you able to take Mr. Johnson into custody?
Yes.
Can you describe that a little bit? What happened while you were trying to take him into custody?
I pulled him to the ground and put him in handcuffs.
And once you put him in handcuffs, how'd you proceed from there?
Once I got another officer on scene, I got it's just called a removal tool. I removed the taser probe and then put him in another officer's backseat.
Do you recall which officer's vehicle you put him in?
I think it was Officer Ellis, but I'm not 100% sure on that.
And was that the end of your involvement in this case?
No.
What else did you do in this case?
I responded to the hospital where other officers asked for priority backups that were dealing with Mr. Johnson, and I put leg irons on him at the hospital.
But when you, when you arrived at the hospital, did you witness any assaults or any obstructions?
I did not.
Okay, thank you. No further questions at this time.
All right, cross-examination, Mr. Austin.
Morning, officer.
Morning.
So trying to understand your testimony a little bit, you were responding to a possible fight that had occurred at the apartment complex. Is that correct?
Correct.
And I believe you also stated that you were also specifically looking for Mr. Johnson, as he may have been wanted by the Michigan State Police for something. Is that correct?
That's correct.
And as it relates to that information about possibly being wanted by the Michigan State Police, was that relayed directly to you, or did that come from some other source?
Came from our dispatch.
At the time you were being dispatched regarding the fight, or another dispatch?
I just don't understand your question.
Okay. Did you receive that information at the same time you received the dispatch regarding the fight, or are we talking about two separate dispatches?
Same time.
And you know the extent of what that may have meant, that he was wanted by the Michigan State Police, that if he had an outstanding warrant or wanted for questioning, or did you know?
He was wanted on a fresh charge of domestic violence out of Eaton County.
Is that something that was relayed to you at that time or another time?
At that time.
And so then was it your intention to detain him and do an investigatory stop as it related to the fight? Or was it your intention to place him under arrest regarding the matter from the Michigan State Police?
Both.
Okay. And did you check to see if he had some valid arrest warrant out of Eaton County for this matter that you were talking about?
Did not. He was to be arrested on probable cause. And Michigan State Police told us they would take custody of him if we located him.
Okay. So in other words, there was not any type of active warrant regarding that situation in Eaton County, then, correct?
Right.
Okay. And whatever probable cause may or may not have existed for that matter, it's safe to say you didn't have any personal knowledge of it. Is that correct?
That's correct.
Okay. And when you arrived, you were with Officer Fox?
I was.
Okay. And at some point in time, did the two of you kind of get separated as you were looking into this matter?
Yes.
Okay. And how far away were you from Officer Fox when that happened?
When we got separated,
Yes.
well, we separated when we saw him walking away. So I began walking towards him, Fox went to his patrol vehicle. So I don't know what distance that would be. Half a block.
And you said you saw Mr. Johnson walking, is that correct?
That's correct.
Okay. And at that point in time, you saw him walking, you had not observed him commit any kind of crime at that point, is that correct?
That's correct.
You did not see or hear any type of fight or arguing taking place when you had arrived on scene, is that a fair statement?
Not when I arrived.
And you did not see a female in Mr. Johnson's vicinity when you had arrived on scene, is that correct?
That's correct.
Thank you, officer. That's all the questions I have.
Any redirect, Mrs. L?
No, Your Honor.
May this witness be excused from the people,
You may, Your Honor.
from the defense?
Yes, Your Honor.
Thank you for your appearance today. You're excused.
Thank you, Your Honor.
And Mrs. L, any further proofs today?
That's for Your Honor. At this time, the people would like to move for a continuance, just a brief one, as we were unable to get Jake Ellis here today. However, Your Honor, in all honesty, we do not have a reason why Jake Ellis is not here today. So we would leave it to the court's discretion on that continuance. If the court is not willing to grant that continuance, we are ready to move to find over arguments.
Any concerning this matter, Mr. Austin, we've gone through two witnesses, Mr. Fark, our officers Fox and Turvo. We've started the preliminary examination. We have a third witness request for adjournment. We don't know the reason for the non-appearance of the witness. This is the day before the 4th of July. So, but any record you'd like to make, Mr. Austin?
Well, as it relates to that, Your Honor, I would oppose any motions for an adjournment for a number of reasons. One, Mr. Johnson is in custody. He's in custody on this matter. There hasn't been sounds like any prior communication with the people and the witness as to the reason why for his non-appearance. And we also, not only do we not know the reason for his non-appearance, but we also don't know the extent, if any, to his unavailability. So I fail to see that there's any good cause given that lack of communication as it relates to that witness. So I would oppose any adjournment requests.
All right. Any adjournment would be with the subpoena would go out, and that would be done without knowing his schedule. But that'd be tantamount since we started the prelim onto any response, Mrs. L.
Your Honor, this officer is an officer that generally shows up when subpoenaed. He was subpoenaed today. He did see that subpoena. Usually this officer is very good at communicating with us. Unfortunately, we do run into the situation where sometimes officers communicate with different APAs in our office with different cases, and it doesn't always get conveyed to us. I have reason to believe that Officer Ellis would appear at a continued date. But again, in all honesty, we do not have a reason today nor communication.
Right. This is the first PCC. This is after this was left on from the first PCC. The preliminary examination was started. So the adjournment is granted concerning the non-appearance of Officer Ellis, which would be the final count concerning any activity But he is also a complaining victim of the final count. And so we will adjourn or grant the adjournment. And I'll write the name down in the ROA so to know that's who the adjournment is for. It's for Jake Ellis adjournment. And then we'll reset the preliminary examination for some time. We've already started it. This is an adjournment in regards to an already started preliminary examination. And we'll adjourn to what date?
July 24th at 9.
July 24th at 9 o'clock. So it's a good cause adjournment to adjourn. Anything else for the record in docket 25-01766, Mrs. L?
Not for people.
Mr. Austin?
I would just ask, given that there is a delay in this matter that is not attributable to Mr. Johnson, if the court would grant him some type of relief, either in the form or the amount of his bond.
Thank you. Mrs. L, anything in regards to bond? The bond is set at 25,000 cash surety. It was set by, it looks like Judge Ward. I think it was Judge Ward.
I believe so, Your Honor. I believe it was on a weekend arraignment.
A weekend arraignment on Judge Ward for 25,000 cash surety. Anything, any indication or anything response, Ms. Azell?
Thank you, Your Honor. Based on the testimony today, the people would oppose that motion for bond reduction due to the fact that there has been testimony about this assaultive behavior in this case and an injury that was caused to an officer. But we do have concerns with that bond being reduced. Thank you.
As to Judge Ward's bond of $25,000, the modification is denied. Judge Ward tends to be fairly lenient in regards to bond in these matters. And so I'm not going to question her reasons for setting bond at 25,000 cash surety, and the modification of bond is denied. Anything else for the record in 25-01766, Mrs. L?
No, thank you, Your
Mr.
Honor.
Austin?
No, Your Honor, thank you.
All right, thank you. And those are the notes. So we'll see everybody on the adjourned date. I think that's the docket.
I believe so. Here we go.
All right.
Just before noon, too.
Thank you for your help today, Mr. Austin.